Hi, this is Rahul Reddy. We are live here from Houston, Texas. Along with me is Emily Newman, my business partner. We are here to present as usual every day, every week on Tuesday at 5 o'clock live for you for question and answers on immigration. We're bringing all the topics that you need to know in business immigration. Emily?
Thanks for joining us today, live from Reddy and Newman PC, where we practice only immigration law and only employment-based immigration law. So we're here to provide you with the latest news as well as answer your questions here live. If we don't get to your question today and you'd like to speak with one of our attorneys, you can always set up a consultation with us by going to rnlawgroup.com. And you can always get more updates with the latest news and chat information by going to immigrationgirl.com, following us on Twitter at rnlawgroup or at immigrationgirl. So we always have new updates happening.
Every week.
Trump
administration.
Yeah, so I think one of the most recent updates was the announcement that the NTA memo is going to take effect from yesterday, October 1st, for certain applicants. So can you tell us a little bit about who is impacted by the NTA memo? What is the NTA memo? Kind of take us back to when that was first issued.
NTA is also called as notice to appear. When the immigration feels that the individual is not a U.S. citizen and is not maintaining the legal status in the United States, they will issue a notice to appear in front of the immigration judge so that he can explain his reasons why he is staying in this country legally. That is what notice to appear is. Now, normally this notice to appear is used when cases involving criminal cases, when the person goes out of status and stays here for a long period of time, they do issue a notice to appear. However, in May of June of 2018, USCIS issued a memo indicating that they might be issuing a notice to appear for most of the cases where the person appears to be out of status. Now, Emily, having said that, for those law-abiding people, immigrants in United States, is there a fear for them? I mean, sometimes they fell out of status. And when they do fall out of status, they would like to rectify their status or they would like to go to their home country. Does this notice to appear is applicable for those law-abiding non-immigrant visa people who almost try to be in legal status, but some mistake, they fall out of status and they are now wanting to leave the country or trying to correct their system?
It could, honestly. I think that with this new announcement that came out, they gave us a little bit more information saying that in the event of a denial, they will give you a certain period of time to make plans to depart. That's generally going to be the time period where you have the option of filing an appeal. So we haven't seen this in practice yet, but we're expecting when they issue a denial notice for someone whose I-94 has expired by the time of the denial, they will say you now have 30 days to depart. And as long as you leave during those 30 days, no action should be taken by USCIS to issue an NTA. It's when you stay beyond the time given, that's when you may be subject to an NTA. So yeah, even if you're trying to correct the issue, you may end up having to exit the country anyways as a way to ensure that you're not going to receive this NTA. But as of right now, the memo is only applied to two types of applications, the I-485 or the I-539. So if basically your green card application, the last step, the I-485 gets denied, and you've not maintained your underlying non-immigrant status by extending your H-1 or your L-1 or whatever status you're on, so that by the time a denial happens, your I-94 has expired, then you could be issued an NTA if you don't leave within the time specified. Also for I-539s, if you are on H-4 or L-2 and you filed an extension and maybe you filed it with your spouse's extension and the main applicant gets denied, it's going to cause yours to be denied as well, but you're the one that would be subject to the NTA, not the main applicant. And again, this is only if you don't leave within the prescribed period.
And what is that prescribed period?
We don't know, but in the teleconference, they made it sound like it would be the time period for filing an appeal, which is usually 30 days. But they did suggest that they will actually put a time period in the denial notice and let people know that you will be subject to an NTA if you don't take action by a certain time.
So at this point of time, we cannot safely say that if they live within 30 days, they won't get an NTA. It's just an estimate that based on some of the wordings that they used, and since that 30 day is the appeal period of time, we are just estimating that it's a 30-day safe. If they live within 30 days after the denial, they may be safe, but we are not sure about it at this point of time.
Right, yeah, we have not seen any NTAs issued yet for denials of 485 or I-539, because we haven't had any denials of 485 or 539 since yesterday, thank goodness. Hopefully it'll stay that way. But yeah, it's definitely something to watch for spouses of high-skilled workers. It impacts the spouses more than the actual worker.
Emily, we have this memo that has become effective on September 11th, that the USCIS might deny the applications without issuing a request for further evidence. When we file an application, normally when of any immigration benefits, normally when the immigration is not satisfied with the evidence provided in there, the USCIS requests the applicant to have it called request for further evidence, which they will ask, can you provide me further evidence why we should approve this case? Now, that memo went into effect on September 11th of 2018. Have you seen any denials, and what is that you're expecting for mostly law-abiding non-immigrant visa people in the United States?
No, we haven't seen any denials. And of course, this only went into effect from September 11th, so it's just been a few weeks. But that being said, we're not really expecting a main impact of this to be on typical, high-skilled workers, law-abiding immigrants. It's more meant to, I guess, prohibit filings that are on their face just completely the wrong type of application, or the person just doesn't qualify for the request that they're trying to make, or placeholder filings are being done where people will supplement later with all of the documents. Those are the typical cases where USCIS could deny. Again, we've not seen any denials in this since that memo took effect yet, so we don't really expect that for the most part it will be impacting many of our clients.
Emily, any update on the H4 EAD? I know last week, there was a code things that you updated on your immigrationgirl.com. Have you any more updates on H4 EAD?
Yeah.
Can they file for the H4 EAD an extension right now?
Yeah, main takeaway is you can continue to file H4 EAD for the first time. You can continue to file renewals. So nothing has happened with the existing regulation. We do know that probably by the end of the year we'll have a proposal. Again, it's just a proposal. So even after they propose it and they publish it in the Federal Register, you can still continue to file for H4 EADs and renewals. There will be at least a 60-day comment period, followed by months and months of reviewing before a final rule can finally be issued. Once a final rule is published and takes effect, only then will a change actually take place. So during the entire regulatory process, you can keep filing. USCIS will continue to approve those applications. All we know is expect a proposal to be announced probably sometime by the end of the year.
Emily, with this cap gap, USCIS has issued the notification again one more time, reminding those people who are in cap they cannot work starting from October 1st of 2018. Are they legally allowed to stay in United States after their cap is over and they are not allowed to work in United States?
Yes. So as long as you filed a change of status, which makes you eligible for the cap gap extension, that cap gap gets you to September 30th. Starting on October 1st, you're still in your F1 grace period. You cannot work, but you can stay for the remainder of your grace period to continue the last part of your F1 status. Now, if you continue to stay beyond the 60-day grace period, you still can legally stay. At that point, you are in what's called a period of authorized stay, which is also referred to as POSA-BAG, period of stay authorized by the Attorney General. That is for anyone who has a pending application where the underlying status has expired while it's pending. So you can continue to stay based on your period of authorized stay, or you can continue to stay for 60 days based on your grace period. Now, the main thing to be aware of is once your 60-day grace period of F1 ends on November 30th, if you still don't have a decision and you go into December, January, February, and your H-1B ultimately gets denied and you've stayed that whole time, you were allowed to stay that whole time. There's no unlawful presence while you stayed, but from the day of the denial, the next day you're immediately out of status, you're immediately accruing unlawful presence, and there is no grace period. You cannot go back to F1 status at that point. So if you're planning on re-enrolling in school or continuing your studies as a way to continue your F1 status, you have to get that new I-20 before November 30th, or if you're H1, before November 30th, basically. Otherwise, when you get beyond November 30th, if you then end up with an H-1B denial, you're going to be out of status, and it's not possible to get back into F1 status without exiting the country, getting a new visa stamp, and all of that.
We'll go to some live questions. I have here Praveen, who's asking, filed an MTR for the H-1B, and the processing time is telling that it's December 27, 2017. What are my options? If you filed a motion to reconsider, I would recommend that you contact a lawyer immediately, because there are some options which if you're staying in this country, you might be risking your stay here completely. You may want to consult a lawyer, because a lot of times motion to reconsider is not the best option, particularly when it is taking so long period of time. Do you still have the underlying job? If you don't have the underlying job, there is no purpose for the motion to reconsider to be there, because then you need to withdraw that application. So you might want to consult with a lawyer to see what your options are.
All right, Abhishek has a question about the online I-94. When you are traveling into the U.S., you get your I-94 number by going to the CBP website online. Once you're here, when you file your extensions or your transfers or change of status, your new I-94 is going to be issued by USCIS on your approval notice. So if you entered before the online system came into effect, you won't find your I-94 online. And if you did enter and then later changed your status, extended your stay, or filed a transfer to where you have a new I-94, that will never reflect online. It only comes by paper from USCIS.
Anu has this question. Is there any way I can make sure that the previous priority date has been ported to this I-140 when previously I only got my perm approved, but the I-140 is not approved? If the I-140 has been if your previous underlying labor does not have an I-140 approved, you cannot port the date into this new I-140. You cannot port that. Sanket has this question that I'm working on H-1B with one company, but another company filed for H-1B. Is that something legal? Yes, it is legal. I don't see that any issue if you have a job offer with the other company. However, I might want to be a little bit more cautious. If both companies are filing H-1Bs, we doubt that there is something wrong in it, because I think so the reason why they are doing it is try to circumvent the lottery process though. So, but if the main company that you're working is not filing, the secondary company is filing H-1B, we don't see technically as a problem.
Yeah, on that note of filing multiple H-1Bs with different employers, I'm seeing it a lot right now for people who are on H-1B filing an extension with their current employer, and as kind of a backup plan, they're filing a transfer with a different employer. Now, in theory, that is allowed. There's nothing saying you cannot do that. You can have two different applications pending at the same time. In practice, however, what we're finding is the two companies have some sort of relationship, or maybe the person is going to be assigned to the same job, the same project.
So the job is only one,
exactly,
and one company is filing an extension saying that it's their job, another company is telling that it's their job. Is that what you're telling, Emily? Uh-oh.
Yeah, so that's going to be a huge problem. And USCIS does keep track of these things. They do see when two companies file for the same person, and if they see a pattern of that happening, they will raise it in a request for evidence or possibly even a notice of intent to deny. So I would definitely, I understand the fear of why you're filing that transfer as a backup plan, but it may not be the best plan in the long run if there's no other job available at that transfer company.
Yes, you're telling both jobs are the same.
Right.
That doesn't look good at all for me. Kaushal has this question, Emily, that his OPT is expiring in December 2018. His company is not an e-verified company. Can they now do the e-verification and file an extension for the STEM extension?
They can. They need to start that process right away because sometimes the registration process can take some time. But yes, as long as by the time you're filing your I-765 application, they're an e-verified company at that point, that's fine. But companies need to be aware that it's not just about enrolling in e-verify to allow someone to get the STEM extension. They actually have to participate in the e-verify program for every single person they hire from that date going forward. Not just for OPT STEM students, not just for foreign workers. Every single person they hire from that date going forward has to go through the e-verify system along with the I-9 paperwork that they would normally do at the time of hire. So I think sometimes companies get confused thinking that I'm doing e-verify for this person so they can get the STEM extension, so only the STEM people have to be run through the system. That's not true. Once an employer enrolls in e-verify, they must use it for every single new hire, regardless of status, regardless of the type of work they're doing. Everybody has to be run through the system.
Murli has a very tough question for you, Emily. He already knows that once you file the H-1B transfer application, you can work with the company B when they file the transfer. Is he asking, is it safe under the current circumstances to work on a receipt notice?
Yeah, it's a great question. I just did a consultation on that exact issue this morning. And it can be. But there are certain kind of safeguards that you need to do before you make the leap and actually join that new employer. Number one, file it. I wouldn't file it if my I-94 is expiring in the next few days or months. If my I-94 is valid for at least 6 months, maybe even longer, that's a little bit better situation because it's unlikely that your underlying approval notice is going to expire while the transfer is pending. You don't want to get into a situation where you file your transfer, you join that company, your I-94 expires, and then you get a denial. That's where in the future we're expecting the NTA memo to take effect because you will then be unlawfully present on the day the denial happens, versus if your I-94 is still valid at the time a denial happens, there is no unlawful presence. So that's one nice thing. Another thing you can do to kind of safeguard yourself is just be familiar with the company you're looking to transfer to. Make sure that they have an attorney that knows what they're doing as best you can. Make sure that they're filing your case in a strong way with a good SOC code. That's that occupation category that you select on the LCA at the very beginning of the process. make sure that they're filing with the proper wage level. Check the Occupational Outlook Handbook entry to see what it says about that occupation code as far as education. If it says that employers will accept a bachelor's degree or an associate's degree, or any field of study qualifies for this job, you're going to have trouble with specialty occupation. I think it really, if you've got a strong case, a strong job, the company is a known company, then you probably have a relatively safe transfer.
Emily, Murli brought in a lot of very tough questions. Is it safe? I mean, it's very, and you said, you threw the word SOC code, you said occupation outlook, the job title is proper. I mean, our audiences are not immigration lawyers. And being an immigration lawyer, and you've been an immigration lawyer for a long period of time, what have you noticed in the past 2 years after this administration came in, before how it was, after how it was, how many denials were you been getting before, how many denials you've been getting right now?
Yeah, it's definitely a different ballgame. The level of scrutiny is higher. There are certain occupation codes, especially in IT, that we were getting approvals, no issues for years and years and years, and then all of a sudden we get a denial in every case. There are certain wage levels, like wage level 1. We never were questioned on wage level 1 for the past 20 years. And then all of a sudden last summer we started getting that question. So definitely it's important to keep an eye on these trends, to work with an attorney that files a large volume, because they can apply what's happening in other cases and what they've seen, what their experience is to your case, to give your case a better chance of success. So it's very different than what it was 1 to 2 years ago, but it's not impossible. We are still getting approvals.
Yeah, well, but we're getting more denials to compare to.
Not right now. Things are going, knock on wood.
The other solution, what I would suggest, Murli, is because, Emily, these people, they have families, they have kids going to school. I would suggest to Murli is to have the copy of your H-1B petition with you. Have it reviewed by another lawyer, a competent lawyer, and see what are the deficiencies that they feel. And I feel that, a lot of times when I see in the employer letter or the end client letter, they are listing that the position, in the software positions, that the position requires computer science, engineering, or mathematics. Those kind of things which used to be okay in 2016 are getting assured denials right now. And so, as Emily was pointed out, that there are certain safe SOC codes we've been using all along, and now all of a sudden we've been getting denials with those things starting from 2017. The wage level 1, and that used to be, we used to get, never been questioned, and that started getting denial in 2017. I would advise you guys to get a second opinion. It's very tough for you guys to evaluate your own case, to see all the SOC codes, to study whether the position requires a bachelor's degree or not, to understand what the trend in the immigration at this point of time. And when you are taking a life decisions right now, if I were you guys, which at one point of time I was a client of immigration lawyer, I would get it revived by another immigration lawyer to see if there is any deficiency in the application. I would get a copy of the H-1B application from the employer and give it to a lawyer to have it look, so that he can give his honest opinion whether there are any weaknesses in the case.
Yeah, I think that's really important, is to know before you file if there are any red flags, what are the potential weak spots, and then you can make an informed decision about whether it's worth the risk in filing the transfer and joining that company. I think that a lot of times, there are cases that are filed that could have been filed in a different way or with additional documentation that could have resulted in an approval, but end up with a denial for something so minor that you wouldn't think of. But had it been caught before filing, it could have completely changed the outcome of the case. Vijay asks a question about the dependent approval notice for an H-4, and that is a good question. Typically, if you file for multiple family members, say your spouse and your child, you'll get one receipt notice mentioning both names, but at the time of approval, you should get an approval for each person. So your 3-year-old son should have their own approval notice for the H-4. So if you have not received that, you or the attorney may need to contact USCIS. We have seen a couple of missing dependent approvals lately in our office as well.
Abhishek has this question. His wife's H-4 EAD is expiring in November, and she has filed an H-4 EAD extension. Can she continue working after November if the H-4 EAD is not approved? No, sir. You cannot. She cannot continue working if the H-4 EAD is not approved. After November, they have to cease working. Vaibhav has this good question. Well, I don't know whether he's kind of jealous. He has his wife is on H-4 EAD and is getting more salary than the H-1B. Is that a problem?
Not at all.
Not at all. Absolutely.
Great. Enjoy it.
Enjoy the money. Why not? Pay the taxes, enjoy the money. Absolutely no problem. I'm just kidding. I was on the H-4 EAD before I became an immigration lawyer, guys. Oh, not on H-4 EAD, but H-4, yeah. Sorry. One question that been raised here, Emily, is that the H-1B, we have received the receipt notice for the H-1B in 2018. That means filed in the new quota, and nothing, no approval, no RFE. Is that common right now?
Yeah, join the club. We have probably about 20% of our pending applications. We've still had zero action taken since April. You know, I was thinking about this the other day. It's not like USCIS wasn't aware how many filings there would be. It's not like they're having to adjudicate everything that was filed in the lottery. They know exactly how many cases they're going to select. They should know how many officers they need to get them all approved by October 1st. Yet last year and this year, they're just taking forever to process these applications. So yes, you're not alone. Many other people have seen no action taken on their cases that were filed in April. You know, it can continue on. Last year, I think we had received our final approval notice on April 1st of this year. That case did have a request for evidence on it, but we were still getting first requests for evidence in December and January from cases filed last April. So I expect that to happen again this year.
Sham has this question, Emily, that he has got a H-1B approval and he's a licensed pharmacist and he worked with that company for 6 months on the H-1B. Can he now file a transfer and move to a different company?
I don't see why not. Maybe I'm missing the question.
Yeah. Yes, you can. He got a H-1B approved. He's already working 6 months as a licensed pharmacist. Absolutely no problem. You can file for a change of employer. That we don't see that as an issue at all.
Yeah, just if you're going out of state, you need to have the license and that in that state before you file the transfer.
Before you file the transfer, that's right.
Chandra has a question about transfer as well. What if I'm working for my current company and I file a transfer but never join the transfer company? Is that a problem? No, it's not. Just because the transfer is filed doesn't mean you have to join. And just because it's filed, it has no impact on your current approval with your current employer. So no, it's not mandatory that you have to join that new company.
Emily, can you update the premium processing has been suspended. In limited cases where the premium processing is allowed, and what are those limited cases? When is the premium processing is expected to come back?
Yeah, so the only cases that can be filed in premium right now are H-1B continuation with the same employer without change. That can be filed either as an extension or requesting consular processing if you're going to be exiting the country while it's pending or before it's pending. But the main point is you have to select the box for continuation with the same employer without change. And that has become a topic of much conversation in our office, is what can be considered a continuation without change. What if the salary increased by $5,000? Can I file that as a continuation without change? What if the office building, the suite number that I work at switched, we moved up a floor? Can that be considered an extension or a continuation without change? And I think that it really is what's reasonable. Is it reasonable that the major issues related to the job are the same? There's not been a material change. So if the suite number changes, I'd probably be filing that in premium. If the salary increased by $5,000 because cost of living went up, it wasn't due to any change in job duties, I'd probably be filing that without change. So there are ways that you can try to get it into premium processing, depending on, it's completely dependent on how the I-129 form is filled out.
The transfer, one of the question is, the transfer got denied. Is the current H-1B still is valid? Can he continue working with the same employer if the transfer gets denied? Absolutely, you can. Your current H-1B is fine. You can continue working with the same employer, no problem at all.
All right, Stenthal asked if he can file a transfer, I'm assuming beyond the 6-year limit, getting a 3-year extension, if you don't have the actual I-140 approval notice copy, but you at least have the receipt number. And yes, we've been able to do that. We will typically take that number, enter it in the USCIS online case status system, and print out the case status showing that it's been approved, and keep that in the filing. And USCIS should be able to look up in their records and see that that is an approved I-140 for you, and be able to adjudicate that with a 3-year extension.
Sohail has a good question, Emily. I know we have been discussing about this EB1 A, B, C portability. He has a EB1B, which is outstanding researcher. He got his I-140 approved. His adjustment of status 485 is pending for more than 6 months. Can he now port to a different company using the 485J supplement?
Yes, I don't see why not.
That was I was a little bit at the time when I was understanding it. I was a little bit confused. I thought that you cannot, but after the long research and discussion with me, I found out that EB1B can file a 485J supplement and port the employer to a different employer. However, I would like you to be very cautious to choose a lawyer to represent you, because both jobs should be similar. If both jobs are not similar, you might get a denial. Now, when it comes to the EB2 and EB3 portability, it's quite different, and mostly the jobs will be similar or same. But when it is EB1B, I would like to make sure that everything is perfect before filing the 485. I would be more careful than what I would be in EB2 or EB3 for portability. it.
Yeah, especially with the NTA memo applying to 485s. You don't want to end up in a situation where your 485 ends up denied and you've let your underlying status expire. Now you're subject to an NTA. Anant has a good question for his spouse. She wants to go for H4 stamping. Is it possible to do that without the main applicant H1B holder? Yes, absolutely. It's not necessary for the H1B holder to go for stamping with the H4 spouse. The spouse can go on their own. No problem there at all.
Monica has this question. Can you give me information on H4 EAD? When can I apply for my spouse after I've completed 4 years of H1B? The EAD, H4 EAD cannot be applied just because the main applicant has completed the 4th year. There are a couple of ways where the person will be eligible for H4 EAD. One, the spouse's I-140 has been approved. The second situation would be that when the spouse is beyond 6 years of H1B. That really happens in 2 scenarios. One is when the I-140 is approved, which we already covered it. Another scenario would be that when the labor certification is pending for more than 1 year, you will be eligible for the 7th year of H-1B. At that point of time, H-4 EAD can be applied. Just because the main applicant is 4th year of H-1B, and if they don't have an I-140 approval, they cannot file for the H-4 EAD.
Anand has a question about, okay, I misread the question, but I'll answer a different question. If you have your I-140 approved for 180 days, is it then safe to transfer? Without dealing with the premium processing issue for the H-1B, when we're talking about the I-140, yes, you can transfer to another employer, use that approved I-140 to get an H-1B extension for 3 years. Your spouse is eligible for the H-4 EAD, even though it's with a different company, and you can retain that priority date. And that is true even if that previous employer eventually withdraws the approved I-140. So you can use that I-140.
And you can also use that I-140 not only to extend the H-1B with company B that you're going to move on, even if you move from company B to company C to company D, you can use the same I-140 which has been approved for more than 180 days before it's been for forever. You can be using that. So no problem with that. It's kind of it's a regulation right now, so I mean it's pretty safe that once the I-140 has been standing there for 180 days, it's not been withdrawn. It's a regulation, and USCIS is not going to interpret the other way around on that.
All right. Still getting a number of questions about who's eligible for premium processing of an H-1B. The only thing that can be filed in premium processing is the H-1B extension without change with the same employer. You cannot file an amendment, you can't file an amendment plus extension, you can't file a transfer, you can't file a change of status, you cannot upgrade any of those things that I just mentioned. Only extensions with the same employer that go to Nebraska can be done in premium. If you were able to upgrade your case before September 11th to premium processing, that means that within 15 days of the time of the upgrade, you should be getting a result. That result could either be an approval or a request for evidence generally. If you get a request for evidence, once the response is submitted, it takes another 15 days before you can get an update on that. If it goes beyond the 15 days, then a refund can be requested.
I have this question here that the H-4 EAD person has only, that person has a H-1B, only 2 months left in that previous 6 years of H-1B, but the person is on H-4 EAD right now. What should they do when there is a chance that the H-4 EAD extension might not be coming through? One small and easy solution for you is that on H-4 EAD, you could file a labor certification and you could file an I-140, and then you can resurrect your H-1B even though you have 2 months of H-1B left after the 6 years. Once you have the labor and I-140 approved on the H-4 EAD, you could use that one to extend the H-1B, not just the 2 months left, but you can apply for three years of H-1B. On H-4 EAD, you can file the labor certification I-140.
Raja has a question about H-1B stamping. If you have an H-1B stamped with your current employer and then you file a transfer to the new employer and that gets approved, you're working for the new employer, now you want to travel. Do you have to get the new visa stamped with the new employer, or can you continue to use your existing visa stamp? As long as the existing visa stamp has not yet expired, you can use it even with your new employer. So at the port of entry, you'll provide your old visa stamp with the old employer that has not expired, and you'll provide your approval notice for your H-1B transfer showing that you've been approved, and you should be given a new I-94 through the end date of the transfer approval notice. So yes, you can absolutely use that old visa stamp, but be aware sometimes your I-94 accidentally gets given only to the date on the visa stamp, which is generally going to be your previous approval notice. So before you leave the airport, you need to check what date they stamped in your passport and make sure they gave you the full period of time A lot of times they do give a shorter date there, and once you leave the airport, you're limited in your choices for getting it corrected. Some people don't realize it until after it's too late, after it's already expired, and then there's really no way to correct that situation. So definitely keep an eye on that and make sure you're given the correct date if you travel in that situation.
Still more questions coming on the premium processing as people are worried. The premium processing cannot be applied when you are applying for H4 to H1 change of status. No, you cannot apply from H4 to H1. And you cannot work with the receipt notice if you are changing the status from H4 to H1. You cannot do that. Now the other question is that I have filed an I have filed an extension without amendment, and I did not file in premium processing. Can I now convert into premium processing? As Emily has pointed out before, that if the extension is been filed without any amendment in Nebraska Service Center, you can still upgrade that one into premium processing. But I want to address this 240-day rule, Emily. What is this 240-day rule? When you apply for the extension of status, is that you can only work for 240 days after you file an extension or after your I-94 expires? And under the current situation, if the employee has filed amendment plus extension, now there is no premium processing and the sweet old USCIS is taking forever, what are the solutions when the I-90, when they cross the 240-day rule?
Yeah, so one thing to be aware of, the 240-day rule does not apply to all types of cases. It only specifically applies to extensions with the same employer. So if you're filing a transfer, the 240-day rule does not apply. The transfer falls under AC 21, which says you can continue working for that new employer as long as the transfer is pending, even if it goes beyond 240 days. So we're only talking about filing an extension. Now, when you file your extension, if while it is pending, your I-94 expires, you can only work for 240 days from the day your I-94 expires based on the pending extension. It's not based on the date of filing the extension. From the day your I-94 expired while the extension was pending, your employment authorization only lasts for 240 days. If your application is still pending at the 240-day mark, you either stop working and you stay in a period of authorized stay without working, or file another extension to extend the 240 days for another 240 days. We do that from time to time. Most of the time, our applications don't get to the 240-day mark. We'll see now that we don't have premium processing if that continues. Yeah. But yeah, you definitely need to keep an eye on that 240-day clock if you're filing an extension and your I-94 expires, and make sure that you get the decision before 240 days or be prepared to file another extension.
I think so. We pretty much covered most of the things. Emily, anything left out?
All right. I think that's about everything.
Don't forget that we are live every Tuesday at 5 o'clock Central Time. And please notice that we have a daily conference call. And if you want to make an appointment with me, Emily, or any of our very good colleagues that we have in our office, you can make it by going to rnlawgroup.com. You can make an appointment with either of those people. And we have a daily conference call that you can come in. That's there on our rnlawgroup.com. Don't forget to be logging into Immigration Girl. Emily updates every time any news comes in on the immigration. If you subscribe to the immigrationgirl.com, you will get the latest news at all times.
All right.